So I want to tell you the story of two sisters and one house. Now the first sister's name is Gina. Not her real name. I'm not using real names in today's video for hopefully obvious reasons. But Gina is the good sister. She's the responsible one. She's the one who always has everything in order and you can always expect to do the right thing. And then there's Lisa, the second sister. She's often less dependable and sometimes makes questionable decisions that affect more than just herself. But they love each other and they are growing up together in the same home. Their mom's home. And as it turns out, mom grows ill and after a while needs help. And that's where Gina steps in. Gina, the good sister, steps in and helps mom in all sorts of ways. Now Gina's got her own house and she's working and taking care of her own life, but whenever she can, she comes in and helps mom around the house. She'll help her pay her bills, she'll help her run errands, take care of things to make sure that mom is living comfortably. Lisa, on the other hand, has not had as good a go. And while, yes, she will help her mom from time to time, basically she's moved back in and has decided since she got kicked out of her old place, she's gonna live with mom and she's gonna do what she can to help mom around the house. And so now she lives there. But over the years, really, it's Gina doing the lion's share of the work. In fact, once mom, unfortunately, does pass away, it's Gina who continues to upkeep the house. It's Gina who continues to, out of her own pocket, pay all of the taxes and all of the upkeep. When the AC goes out, it's not Lisa who digs into her pocket to pay for the bills, it's Gina. When there's a hole in the roof that needs to get worked on, it's Gina who covers it. She sets up for the contractor to come out and she ultimately pays those fees. And this goes on for about a decade. Now eventually, Gina gets to the point where she is telling her sister, listen, I've been carrying the load this whole time and I can no longer afford to do this without some kind of compensation. Will you help out? And of course, Lisa said, I can't do that, that's not my thing. Instead, what Gina proposes, because she wasn't expecting her to simply write her a check, instead, what Gina proposes is, look, I'm going to have to put the house up for lease so that we can cover the taxes and the upkeep of the house. And at first, Lisa was, of course, that makes sense. But eventually, it got difficult. Because Gina recognized that the closer they got to the point where they actually found tenants to take over the house, she was gonna have no place to live. And it wasn't like she had a job. So as it became closer to the point, Lisa decided she wasn't going anywhere. So Gina was essentially forced to issue her sister a notice to vacate. And that's when things got really turbulent. Now, to be clear, this is well before Gina ever came to my office seeking my assistance. No, Gina had done a little research on her own and understood what a notice to vacate was and how it had to be delivered. So she drafted up a notice to vacate and essentially established that Lisa was living there for absolutely free. She was a tenant at will. Gina sent her a notice and said, it's time to go. When Lisa did not move out, Gina went to the local justice court and filed for eviction. And sure enough, eventually the matter was before the Justice of the Peace, and the Justice of the Peace actually awarded the eviction judgment to Gina. And Gina had been able to present to the court that in the Harris County Appraisal District, she was listed as the taxpayer. And she used that document even though the title to the property had not technically transferred over into Gina's name. She was able to use county records to substantiate her superior right to possession, and based on that, she won her judgment. Now, Lisa had appeared, and she did make a presentation to the Justice Court, but it had no effect, and the Justice Court proceeded to sign judgment in favor of Gina. Lisa had also done her own research and had found out that she had every right to appeal this decision, and that's exactly what she did. She filed for an appeal, and now the matter was headed to the county court. Unfortunately, Lisa also went and found an attorney who was willing to take on the case pro bono. And this attorney was arguing in her written response to the lawsuit that Lisa had just as much of a right to the property as Gina did. And that's when Gina came and paid us a visit. Are you presently involved in a situation where you're managing real property, but you don't actually hold the title? Share in the comments what you are prepared to do or how you have dealt with this issue in your own family, if it's happened to you. So Ernie, what would you recommend in a situation like this? Or what should people consider in order to avoid a situation like this? I'm glad you asked. And generally speaking, people come and go all the time, and so we have to be prepared for these kinds of transfers. And one of the more common ones is by leaving a will. And so when our loved ones own real property that they intend to pass down to members of the family, it's helpful for them to leave something in writing, because anybody can make an allegation that grandma promised the property to me when we discussed this the last time I went to visit her. Yeah, and just the same, every other member of the family can swear to facts of a conversation that none of them can actually prove. But even if you could prove an oral conversation or an oral commitment to transfer property without something in writing in the state of Texas, that argument's dead on arrival. And so if you plan to leave property, or if you have a family member who is planning to leave property, the best way to do it is with something in writing, and one of those ways is with a will. Now, some drawbacks on a will are that while, yes, it's a good and effective way to transfer title of property from one person to another, it's also a bit complicated and can be expensive, because the person who receives that property has to have your will probated, and that probate process is inevitably going to cost some money to the county when the matter is filed, but it's probably also going to cost the recipient of that property some amount of money just to go through the probate process, because they're likely going to have to hire an attorney to assist them with the procedures necessary to get title in their name. Not to mention resolving all the other matters having to do with the estate of that deceased loved one. So while yes, it is an effective mechanism for transferring property, it's not the only one, and it does come with a few drawbacks. Another option might be for an owner of property who wants to leave title to another member of their family is to leave what's called a transfer on death deed. What this does is it functions very similarly to a will, but also to a normal deed that somebody uses to transfer title to another, except that the transfer on death deed transfers title only upon that person's death. For example, if I would like to leave a certain piece of property to a child of mine, I can sign a transfer on death deed and file it with the county clerk's records. Now, the property doesn't transfer immediately. So if, let's say 10 years from now, I decide I change my mind and I instead want to sell the property, I don't have to do anything with the county clerk except sell the property and issue that new title to a new buyer. I haven't robbed anybody of anything in terms of an interest that they have already received, because I'm still alive, and you can do that. So you have the authority to operate just as you normally would during your lifetime, even if you signed a transfer on death deed. But assuming you do none of those things and you pass away, once filed, the recipient of the benefit of that transfer on death deed only has to file an affidavit with the same county clerk's office in order to establish that you have in fact passed away, and now title should pass to them based on your having signed a transfer on death deed and never transferred the property to anyone else. Naturally, the benefit of not having to go to the probate court is very clear, but also there's a benefit to the person who signs it that they haven't lost the right to lease the property, improve the property, or sell the property even during their lifetime. They have full control to do whatever they would normally want to do with the property without any consideration of the potential recipient. And so this makes a transfer on death deed a really functional option for anyone who plans to leave property to an individual. However, the only way for this to work is for the property to be in the name of an individual. And so that's not the only option that people have. Sometimes people transfer individually owned properties into the name of a trust or into some entity like an LLC or a corporation or a limited partnership. Now, a trust, an LLC, a corporation, or a limited partnership will not die. And so none of them can sign a transfer on death deed, but each of them can designate how property will transfer upon the death of a certain individual. So if one person has controlling rights in a trust or in one of these filed entities, those rights can transfer, and the documents which form these entities will control how the property is used even after the death of the person who initiated any one of these instruments. Now, what if somebody dies without a will, they didn't leave a transfer on death deed, and they didn't set up an entity that essentially will carry out their wishes going forward? There is another method that people can use to acquire title even in this situation, and it's called an affidavit of heirship. And an individual who dies without a will can have an affidavit of heirship used to transfer property from them, especially if the time to request a probate or an administration of someone's estate has passed. In Texas, that's 4 years. And sometimes people die and they leave property, and more than 4 years goes by before title is ever correctly transferred to an individual or a group of individuals. And that's where a transfer through an affidavit of heirship might be appropriate. Now, what are some of the complications that might come along with an affidavit of heirship? Well, it's determining those heirs. That can be really complicated, especially if there are certain unknown heirs or heirs who simply cannot be contacted for some reason. Sometimes families get so big, or through multiple deaths, heirship is complicated because there isn't a specific designation. So you'll have to go through the intestate distribution, which can be really complicated as you go down each layer of a family tree to identify every specific heir. And this leads to the final complication in a situation like this. It just might be cost prohibitive to go through such an effort. You may have to employ an attorney, you may have to do some extensive research to track everybody down, and the property itself might be encumbered by loans or taxes or other fees that are owed, and all of this adds up to devalue the enterprise. If the house simply isn't going to be worth all the time, the trouble, and the cost, you might just be wanting to let it go. Which is why it makes perfect sense if you are a person during your lifetime who owns real property and don't want to leave an absolute catastrophe for your family members, to talk to somebody like a real estate attorney or a probate attorney or even a business attorney to set up some kind of entity formation to deal with these matters during your lifetime. You're going to do a whole lot of the legwork up front and not leave a whole lot of mess for your family to have to deal with in the aftermath of your passing. I mean, the fact that they're losing you is bad enough. Don't leave a situation that just kind of leaves all of your property in limbo for them to have to fight over. Most of the value will be drained in the process if you make it complicated for them. So let's go back to our story with Gina and Lisa. This matter rose up to the courts on appeal for the eviction. And so Lisa's best bet was to file in a district court claiming her ownership interest in the property. And when she did that, it caused the eviction matter to stall out. And now Gina had to go and seek legal representation to position herself to win in both the district court, claiming that she had a higher right to title, and then back in the eviction court to claim that she had a superior right to possession. Now, yeah, this fight could have gone on for years and years. Instead, what the parties decided to do was reach a settlement. Because one thing that Gina could prove is how much money she had personally invested when Lisa had invested none. And if they were going to be co-owners, they should also have co-ownership of that debt. And so Lisa's claim was that she was part owner, and Gina's claim was that she had contributed to the property and improved the property in such a way that as co-owner, Lisa would owe her just compensation. Ultimately, the parties reached a settlement that included Gina paying off Lisa just enough so that the parties were satisfied that the amount of money that Lisa would be receiving in exchange for her interest passing over to Gina was a fair distribution of funds, considering what Gina had already invested into the property and the benefits she would be receiving by being the sole owner of the property. So this whole fight in the courts could have been avoided if Lisa and Gina's mom had simply taken the time to properly designate the property to either one or both of them as co-owners. That simple designation could have spared them months of fighting in the courts and probably years of frustration. Ultimately, so much of the cost went into the process of reaching this final determination, and all of it could have been avoided if mom had simply made a proper designation. I hope that if you find yourself in a similar situation, you go out and you find yourself a real estate attorney, a probate attorney, or a business law attorney who can help you out. Certainly, one other thing you could do to help yourself out is check out videos that we've got on this page, over 1,000 of them, to help you manage your property and better position yourself to avoid trouble like Lisa and Gina. So if you've enjoyed today's video, we hope that you give us a like. If you have a question or a comment, please leave that below. I personally respond to those myself. And if you're not yet a subscriber, please consider subscribing. This video right here is the next best thing that YouTube seems to think is perfect for you. We ask that you check that out. And until next time, landlords, happy leasing.